Good afternoon. My name is Judge Carolyn Nichols. I also am a common pleas court judge in Philadelphia County. Thank you so much for having me here. I've been a judge since 2011. It's serving in the criminal court division. Most of the cases that I handle deal with family violence, domestic abuse, child abuse, sex crimes. So I conduct a lot of jury trials, between 30 and 40 jury trials a year, over 100 in the last 3 years. So I'm very familiar with the jury process and how powerful the jury process is. I always tell my jurors that by coming into the court, you transform the Constitution from a piece of paper into a living, breathing document. You make the Constitution live because you ensure that we're going to have a fair and impartial jury trial. So like, oh, this isn't something to get out of. So they kind of light up. Before I became a judge, I was a lawyer for 20 years, practicing civil cases, civil rights cases. One of the last cases I handled before I did become a judge, a case involving African American Latino kids that were prevented access from a pool, some about justice, and that's what I want to do for the Superior Court. Thank you. Yeah, as a judge in the criminal court in Philadelphia, I have hundreds and hundreds of cases per month, conducting jury trials, waiver trials, pleas, motions. So you have to learn how to kind of coordinate and move things together, always recognizing, at least the trial court level, you're dealing with people that are in custody, they've been in custody for a while. You have to realize that every case represents not just an individual defendant, but a family, a community behind that. There's a job that a person can't get to, or they might lose everything. So you need to understand that the decisions that we make as judges are real. They're real consequences and they affect real people. So they always have to have that in your mind and not get caught up in the paper. I understand Superior Court gets approximately 8,000 appeals per year. So that certainly is a heavy caseload, but certainly it's something that I welcome because a lot of what I'm doing now, respecting the rule of law, respecting diverse communities, respecting the people behind the cases, and ensuring that I move expeditiously. Because when I have clerks, the buck stops here. It's my responsibility, no one else's but mine. So I have to be willing to work harder than anyone else. And that's the kind of work ethic and integrity that I bring to the Superior Court. For me as a criminal court judge, obviously the mandatory minimums has had the most impact, but also there have been several cases involving the Fourth Amendment exclusionary rule applying to parole violation cases, so that's a different standard. We get a lot of parole and probation violation cases, so that's a different standard. Fourth Amendment protections in the Birchfield case, which now applies, so involuntary blood draws in DUI cases, are intrusions, warrantless blood draws, so that it certainly is very relevant in DUI cases. That involves different standards. Also, just a personal interest to me, the SRC case, the Philadelphia SRC case, in which I think the Pennsylvania Supreme Court determined that the Philadelphia SRC board violated the Constitution by the application of the distress law in terms of they were able to disavow the school code and cancel out collective bargaining agreements and things like that. And the Supreme Court said that was constitutionally violative. So that was something that I followed just for my own personal interest, as well as charter school rulings as well, which kind of flows through Commonwealth Court and then goes up to the Supreme Court. But certainly the mandatory minimums, the blood draw cases, the Fourth Amendment cases, and the changing standards of when and where the exclusionary rule applies have had the most impact on my court. Well, as a young lawyer, I was an assistant city solicitor, and I did have the opportunity to do appellate work before a Commonwealth Court involved with employment cases, as well as before the Third Circuit. I litigated Title VII cases at the trial level in federal court, as well as arguing cases, so I do have that experience. As a trial judge now, I've written over 60 opinions to the Superior Court, and I've learned one thing: the record is your friend. So I've learned as a trial court judge, you want to make sure that you understand the record and how the record works, because when the case goes up to Superior Court, that's what the Superior Court is looking at primarily, the record, because other documentary evidence, may or may not get up there. We're finding out. So the record will show the entire history of what happened in that case, what the judge's rulings were, and so that the Superior Court can determine, depending on what the errors are that are complained of, whether there was a legal error, because it is an error-correcting court. But it's all about justice. Superior Court's about justice, to make sure the overarching concern is not to just look for errors, but it's about justice. Was justice served at the trial level? Did the defendant receive a fair trial? And my philosophy to close out is procedural justice, to make sure that there's fairness and balance and justice in what I do at the trial level, and then the Superior Court level will take care of itself. Judges and money, it can be problematic. I know there have been attempts over the years, well, Judge Moulton talked about since 1850, but since 1968 there were also more serious efforts to try to bring the appointive process back, which was the original process before 1850. And I know there was legislation that kind of was tabled in 2015, which took a hybrid approach, sort of taking the best of both worlds, taking the appointive process and kind of combining it with having at least a retention. So the idea of having a hybrid process where you have a bipartisan citizens nominating panel, with diverse citizens, lawyers, non-lawyers, community people, selecting, evaluating candidates, submitting those names to the governor. The governor selects nominees, presents them to the Senate approves them by 2/3 majority, and then there has to be a retention, up or down, nonpartisan, every 4 years. Has its appeal. But of course, to get that process going requires a complex constitutional amendment, which I think through 2 legislative sessions has to be approved. Then there has to be a referendum. So there are a lot of steps which have not been successful as of yet. As a judge, you just have to be, if you follow the rules of judicial conduct, you can't go wrong. You disclose if you do have attorneys that appear in front of you. I think the language talks about significant amounts, whatever that feels like. If you conduct yourself according to rules of judicial conduct, you can't go wrong. And stay tuned for the resurrection of the appellate process, of the appointive process. As an African American woman judge, I consider myself a living example of living, breathing diversity. And I also utilize my courtroom because I believe a courtroom is not just a place to litigate cases, it's a place to transform lives. So I bring in kids from Overbrook High grad, if I have any Overbrook High in the house, grads in the house, now's the time to holla. But I bring in kids from high schools to come into the court to understand that you don't want to make a mark on your life that you can't erase. A felony is not some kind of rite of passage. It's not cool. This isn't some kind of music video. This is your life. So we bring kids in. I go out into the community because I still live in my same community where I grew up. To go to schools to show people that look, I'm nothing special. You can do what I just did. I go back to my high school and say, look, you can be a judge, you can be a doctor, you can be whatever you want to be. But don't let anybody cheat you out of your opportunity, because what I find in creating diversity, creating opportunities, it starts with the person. If the person doesn't have the self-esteem, doesn't think themselves worthy of achieving anything, you can talk all you want. They're not going to achieve. So I tell young women, for example, he's not that into you if he's trying to get you to carry drugs and a gun in your pocketbook. Don't get cheated out of your future for something stupid. You're worth it. Your life matters. And this is the kind of example that I set in my courtroom in my life to help the next generation move forward. I am too honored to be here, among my colleagues with so many varied backgrounds and people with tremendous qualifications that they're bringing to the Superior Court, or would like to bring to Superior Court. What I think I bring is a very diverse background. I'm diverse myself. As I said, I'm a living example of diversity. My legal background has been very diverse. I've worked in local government, in city councils, assistant city solicitor. I've run my own practice as a civil rights lawyer, and being a criminal court judge for the last 6 years. Really committed to making a difference with following the rule of law, respecting diverse communities, and I want to bring that perspective to the Superior Court, because you have to have a broad base of society. Pennsylvania is very diverse and very varied, and our courts should reflect the population of Pennsylvania. So I'm ready to step up to Superior Court and bring the same diversity, work ethic, and fairness that I'm doing right now in Common Pleas Court.